Here's something no one thinks to warn you about when you hit your 40s and 50s. You're going to have to deal with aging parents. And while it might start with something like a minor medical scare, details related to their health and eventually their death can quickly become the thing that keeps you awake at night. Do they have a will? If so, where is it? What about an advance directive or a power of attorney? All of a sudden, you realize how little you know about your parents' preparation, and then what you have or haven't done for yourself sets in.
This is a true story that Brierley and I both experienced recently. And so, as we prefer to do, we called in an expert to guide us. In today's episode, we're talking with estate and trust planning attorney Jennifer McEwen. She answers all of our questions and also shares some of the biggest mistakes she's seen and how to avoid them. Let's dive in.
Jennifer Justice McEwen is a corporate lawyer who focuses her practice on business planning, estate and trust planning, general counsel services, and tax planning. She works closely with her clients to ensure that their estate and business plans mesh seamlessly and to help them realize their goals. Her exceptional skills have been recognized by Chambers and Partners and by best lawyers in America in the area of trust and estates. She has also been distinguished by Best Lawyers as the 2025 Lawyer of the Year in the area of closely held companies and family business law for the Birmingham market. She is a fellow of the American College of Trust and Estate Counsel. Jennifer serves as co-chair of Women Inspiring Success and Entrepreneurship, an external program series led by Maynard Nexon's Women's Initiative. Jennifer holds an LLM in taxation from New York University and received her JD magna cum laude from the University of Alabama School of Law. She received her BA from Wake Forest University.
Brierley, I'm really excited about this episode and our guest today. And the topic had evolved from our conversations that we've been having off and on for about a year now. Mm-hmm. And it relates to your dad. Mm-hmm. And just stress you were having in your head related to your dad and maybe what he's done estate planning wise or advanced directive wise, or if he's done any planning at all.
Right. Exactly.
And it's been weighing on you a lot. It's been a big stress because you don't really know what he has, what he doesn't. You don't know if he necessarily remembers what he has and what he doesn't. And we finally just decided we needed to know because we weren't sure what all we needed anyway, or what he needed, what we needed ourselves. And we decided we need an expert. Just break it all down for us, because if we're confused about it, then there's got to be other people. And I think our listeners are right in that stage of life.
Yes.
Where we need to be preparing for ourselves, but we're also dealing with parents.
Yes, we are dealing with aging parents. In fact, we had this conversation I can't remember if you were there, earlier this week with two other adults that are probably like a little bit older than us, and both of them have dealt at Switch Yards. Both of them have dealt with and are dealing with aging parents. Mm-hmm. So anyway,
but it's true. Like, I honestly, my parents are in good health, but I don't know what they've planned. Mm-hmm. And it's kind of a not something you want to bring up because I don't see them all that often. So like, hey, let's talk about when you die. But you need to know.
Yes,
you know?
Very true.
So I'm so excited to have you on, Jennifer.
Thank you.
Today.
Glad to be here.
This is your specialty area.
That's right. Yes.
Yes. So Jennifer is a friend. She's also a seriously badass attorney. And so she was kind enough to come and talk to us. So for listeners, here's the backstory that's going on with my dad. He definitely appears to be having some memory decline.
And side note, he lives in your back house right now.
Yes.
So, about 6 to 7 months of the year.
Yes. So he lives with me half the year, and then he lives on his own half the year. My parents are divorced. My brother is the executor of my dad's will, and I'm the executor of my mom's. So we've divided that way. But he has become my responsibility, even though I'm not in charge of all of his stuff.
Yeah.
And you see him on a daily basis now, and there's been some things that have kind of concerned you.
Yes, exactly. So I know he has a will because my brother is the executor. I know he has some version of a power of attorney.
Okay.
Which I know we'll talk about a little bit. And my brother is that person. But anything else beyond when we get to impaired enough to take over, I don't know what he does or doesn't have. And so Carolyn, my dad loves Carolyn. Like, he thinks she is like the cat's meow.
Oh.
And so
We went out to dinner one night, and I think he thought it was a date.
That's so cute.
Yeah.
I love it.
And so Carolyn was like, look, I will help you. I will help you deal with this because he will respond to you.
I just
Or
had a
me, yeah.
relationship with him, like, okay, let's talk about this.
Yeah,
You know,
yeah,
that
that's great.
your own
Yeah.
child can't.
And so we brought up the topic of a living will. No,
Advanced directive.
an advanced directive
Yeah.
is what we brought up. And he looked at me like a deer in headlights.
Oh, wow.
And he was like, what is that? And why do I need it?
Okay.
And that is pretty much when I went from being slightly concerned to losing my mind.
Oh, gosh.
Yeah.
Yeah.
Losing my mind.
Yeah. Yeah.
And immediately texted my brother and was like, tell me about your power of attorney, like what it is, what it gives you, you know. And he was like, I don't know, I got to go read it. I was
Brothers
like,
are great,
Yeah.
but they're not.
Right.
They're not going to give you the level
They
of
tend
detail
to be
that
more
you need.
reactive than proactive.
Yes.
Right?
Yes. So,
Yeah.
but honestly, I realized with us talking about all this stuff that I don't even really fully know, like, what's the difference between, like, what is an advanced directive versus a will? Like, I don't
Sure.
even know all
Yeah,
these
all the
terms and what
terms.
I
Yeah.
need
Yeah.
or what I need to make sure my parents have. So
Exactly.
can you break it down for
Yeah,
us?
and where do we start?
Absolutely.
Like,
Right,
when you hear
right.
this story, where do I even
Let's take
start?
her
Yeah,
dad as the
yeah.
example.
Okay, yeah.
Yeah.
So take your dad, and a lot of what I'm going to say applies to y'all as well, but I'll clarify that. So with your dad, so one thing I do want to point out with your dad, which is interesting, is that he's kind of transient. So a lot of these documents are state law specific. So a question for your dad is which state law, where is he truly a resident, and which state's forms of a power of attorney and advance directive does he need and will, because
Right.
those are all state specific. So that would be a question that I would work on with your dad,
wow.
right?
Right.
And you know, if we decide, where does he go back and forth between?
Between here and Pennsylvania.
Yeah,
And so
so-
everything was done in Pennsylvania.
Right.
But
And so if it's done in Pennsylvania, at least the medical, what I'll call globally the medical directives, which could include an advance directive, a living will, and a medical power of attorney versus a financial power of attorney. Those documents should be on forms governed by the state in which he lives or resides, but they should be respected by Alabama or wherever you are, you know, when, God forbid, something happens. So that's
Okay.
kind of question one. Are we using Alabama forms or Pennsylvania forms?
well, with that backstory, and I can say I think listeners might also have this same experience.
Yeah.
They might live in a different state.
Yeah.
You know, like my mom, for example, goes between Florida,
Right.
New Jersey, and Pennsylvania.
Yeah.
So
Where does she claim residency? Where does she file? So she has to file a state income tax return,
Right.
you know, and claim where she claims to be a resident.
Right.
So I would start there.
And then, but is it worth also having the same in another state? Like,
So-
would it be worth
Duplicate.
him having one here since he's half-time resident here?
Perhaps, because, you know, the practical issue is if he gets sick in Alabama and you take him to the hospital and they see a Pennsylvania form, they have to get their in-house counsel to review it and
Oh my
make
gosh.
sure it is appropriate under Pennsylvania law so that they can respect it.
Oh,
If
Lord.
they see an Alabama one that they're used to seeing, typically they don't have to get their in-house counsel to review it. So again, it just depends on sort of how transient they are, how much time they're spending. You know, I don't think there's legally anything wrong with having. Well, I mean, I could see some issues with having two advance directives, for example, because every state's form is different, you know? I mean, of course, the idea would be you would make the same
Kind of wishes.
general
Yeah.
decisions and wishes under each, but like some forms address issues that Alabama forms don't, you know? So
Yeah.
I would actually recommend using one form in the state in which you claim residency and then, you know, making sure that wherever you are, they respect that form.
Okay.
Yeah, yeah.
And
We
so-
do this a lot for like kids that go off to college. So
Oh.
under Alabama law, you become an adult at 19.
Oh, gosh.
So a lot of my clients say, hey, my kid's going off to college in Virginia and they're 18. And I'm like, well, and you can't do an Alabama advanced directive until you're 19, but let's see what the age of majority is in Virginia. And if it's 18, maybe we go ahead and do a Virginia advanced directive that names y'all as the healthcare proxies so that you can make medical decisions if something happens to them while they're off at college. So again, every age and stage of life, all of us can get sick. All of us can, become incapacitated temporarily or permanently. And so these are really important decisions and topics and forms that all adults need to have, really. So anyway, there's the state law issue, which is important.
Right.
And then, okay, so let's say we decide for whatever reason we're going to do Alabama because that's what I know.
Yeah.
So on the medical side, we have in Alabama what's called an advanced directive for healthcare. That form has two parts to it. The advanced directive part, which is the part where you answer questions about life-ending decisions. Mm-hmm. There's two different situations that it covers. If you're terminally ill or injured, which means that two doctors have said that whatever condition you have cannot be cured and you will likely die in the near future. And of course, you can't communicate for yourself at this point.
Okay.
And then permanently unconscious or in a coma. And again, the definition under Alabama law is that two doctors have said nothing's bringing you out of this coma. So in that situation, when you cannot communicate for yourself, there's two questions. Do you want life-sustaining treatment that won't cure you? It'll just keep you alive longer, and it's defined as like machines, procedures, medicines. And do you want artificially provided food and water through an IV or a feeding tube? If it won't cure you, it'll just keep you alive longer, and you can't chew or swallow at this point. Okay. So those are the questions that you have to answer under the advanced directive part. Okay. That is your directive, that you're saying ahead of time, this is how I want to be treated in these situations.
And are these truly honored?
Yeah.
Okay.
Yeah.
Because I feel like you watch some TV shows sometimes and they're like,
right.
Oh.
Yeah. I will say, in my experience and from talking to doctors and nurses, it takes a pretty long time for two doctors to determine that there is absolutely nothing else that can be done.
They don't make it quick.
People get worried. They're like, I don't want to say no because, what if they declare that in like one day? I'm like, I think it takes a while because they have liability to worry about, right? Mm-hmm. If they declare that too early, they could get in trouble.
Mm-hmm. Yeah.
So I try to caution people that this is a very serious sort of classification, right? Okay. And so I do think it takes a while for somebody to be in that condition before two doctors. It says your doctor and another doctor declare that there's nothing else that can save you at this point.
Okay.
So that's pretty dire, right?
Yeah.
So I walk people through those questions. And then the second part is the living will. And that's where you appoint what's called a healthcare proxy who can make these sort of life-ending decisions for you if you're unable to, with this caveat. So you have three choices. So you go through and you answer yes or no on those questions. And then there's a section that says, I appoint my daughter Brierley as healthcare proxy. And I'll stop right here and say this too. You can appoint as many healthcare proxies as you want. You can appoint them to act together. You can appoint successors, which I absolutely recommend, like son, otherwise daughter. If you say son and daughter,
we have to agree.
You have to agree.
Oh, geez.
If you have three kids, you can say it has to be unanimous, or you can say majority.
Yikes.
So again, there's all this like decision tree that happens depending on who you want.
Okay. Side note.
Yep.
I don't think I want to. This sounds bad. I don't think I want a family member. I think I want Brierley. I've talked about it. I want it to be her.
It can be her. You can name whoever you want.
So that's okay.
Yep. Mm-hmm. Okay. Yep. All right, so once you appoint whoever you want and you decide how they have to act, then the next section of the form says you have three choices in terms of how much authority you want to give your healthcare proxy, okay?
Oh,
you can
my
only choose
goodness.
one. I know. I have the most fascinating conversations with people about this stuff. And so much of it is based on their lived experience, right? What happened with their parents when they're making these decisions for themselves.
Right.
And a lot of times, you bring your dad in and he's looking at you like, what do you want me to do? And you're like, well, give me full power, or I don't want to feel guilty about pulling the plug, So, all right, so here are your choices. 1, Your healthcare proxy has to follow the directions on the form, period. Those are your yes or no questions. To me, there's kind of not a point in appointing a healthcare proxy if all they have to do is follow the directions because,
Right.
you know, like the doctors can follow those directions.
I need a maybe checkbox.
Yeah. I mean, people who don't want to appoint a healthcare proxy and they just want to answer those questions, fine. You know, like, okay, if these are the situations, this is what I want to happen, fine. But if you're going to name a healthcare proxy, I feel like they should have some level of authority.
Yeah.
So anyway, first option is they have to follow the directions on the form, period. So that really just gives them, I would say, authority to be in the room, hear what's going on, you know, kind of access to your healthcare situation and records, but no real authority.
They aren't stopped by HIPAA or anything.
Exactly. And then the second choice says, I want my healthcare proxy to follow the directions as listed on the form, but they have discretion or authority to make decisions about issues not covered on the form. So there, they have to follow your yes or no questions, but if there's some other issue, not terminally ill or injured or not in a coma, they have the authority to make decisions about those issues. Okay?
Do you have an example of
I
that?
don't have a great example. I
think.
haven't found one yet.
Okay.
I'm in search of one. You know, maybe...
I was about to wonder if pain management was one, but that's probably more.
But it's not necessarily a life-ending decision.
Okay.
You know, to me, the advanced directive is really about life-ending decisions. So I'm certainly not a medical doctor, and I'm sure there are other life-ending decisions other than terminal illness, terminal condition, or permanent unconsciousness, but I just don't know them.
Okay, sorry.
Okay. But I always say, like, if you feel super strongly about your answers, at a minimum, at least choose that. So if there is some other situation that I can't think about right now, somebody can make that decision because otherwise you're at a standstill, right? All right. And then the third option is my healthcare proxy has the power to make the final decision about any issue, even if it conflicts with something on the form.
Oh.
So that's all power. So, you know, I would say exactly. So most people choose 2 or 3. 2 is, in my opinion or my mind, is I feel super strongly about these situations, but of course I want the flexibility for somebody to make a decision about an issue that's not covered on the form. And then 3 is, okay, proxy, here are my strong suggestions. You know what I want. But let's say, remember the definition is 2 doctors have declared that nothing can cure you. What if Brierley, you know, isn't getting good vibes from that second doctor and wants a third opinion? That would allow you to go get a third opinion. Or what if there's some, you know, potential miracle drug in trials and you want to give it a couple more weeks or a month or whatever after 2 doctors have declared nothing else is going to cure them. Under that, theoretically, you could give it more time.
Got it.
But that comes with, well, then my healthcare proxy is making the final decision to terminate my life, and does that put too much guilt on them? So that, I mean, there is no right or wrong answer. It is super personal, and people struggle with it, and, you know, but those are our choices on the Alabama form.
Got it.
Yeah.
Wow.
Yeah. It's a lot.
It's a lot.
I know.
So
that's the advanced directive for healthcare.
Okay.
That encompasses the living will.
Okay.
And then another document that we recommend is what's called a medical power of attorney. And the way I describe that is it covers non-life-ending decisions. So palliative care, getting them in physical rehab, agreeing to surgeries or medicines that aren't necessarily life-ending situations, but for whatever reason, they can't communicate their own wishes. And so you have the power. It just, to me, it supplements the advanced directive and it makes your authority more all-encompassing when it comes to medical decisions.
Yeah.
Right.
Yeah.
Right. Or, I mean, and that's kind of the one that I'm curious about when you're talking about like memory issues.
Yeah,
like
exactly.
The bigger picture
like they're
is
not
challenging.
dying, but they're slowly becoming more incapacitated or having mental, you know, issues, cognitive issues.
Right.
And you need to go to the doctor with them and help list. There's a HIPAA waiver built into it too, so it allows you to see and hear their medical information. You know, help them make decisions. You know, so yeah, I think both of those are really important.
Interesting. Okay.
Yeah.
And
So-
are all these, this is a separate form.
That's a separate form. Yep. And for whatever reason, the advance directive is witnessed by two unrelated people, and the medical power of attorney is notarized.
Okay.
Yeah. So again, when we're doing this, we're doing wills, powers of attorney, medical directives. We bring our clients in and we have a notary and witnesses. And so we just do it all at the same time. It doesn't really matter.
Right.
But it is interesting to point out, like if you're doing it on your own,
That's what you need.
yeah, that's what you need
So-
to execute.
Okay. So a living will is essentially your advance directive.
Yeah.
Okay.
It's part of it.
Okay.
Yeah.
Yeah.
And in some states, they may be different documents. Again, I don't
Okay.
know.
Okay.
I'm not a 50 state expert, but in Alabama, it's one document.
Okay.
And we call it a statutory form, in that the legislature, when they drafted the statute that, describes the powers you can give a healthcare proxy in these situations, they have a sort of prescribed form to use.
Okay.
So we started with that and kind of, made it a little better, but the definitions and all that is straight from the Alabama code.
Okay.
Yeah, because that's what the hospitals and stuff are supposed to follow.
So with the context of the living will, are there other things like the financial power of attorney that
Yeah.
you recommend that like what else should, using my dad as the example, like what other forms should we be considering if we're doing a living will?
Yeah. So absolutely a financial power of attorney. So there are different types of financial powers of attorney. One is called like a general durable power of attorney. And so that is one where as soon as you sign it, you are giving your agent authority to act on your behalf with respect to financial decisions. And it continues to be valid even if you become incapacitated. Okay, so it becomes effective as soon as you sign it and stays effective essentially until you die or you revoke it. Okay, and then there's what's called a springing power of attorney, which I generally don't recommend, but some people want these and they're not allowed everywhere, like Florida doesn't allow them. But a springing power of attorney means that it does not become effective until you become incapacitated.
But then you have to get someone
But then
to
you have to
declare-
prove that
Yeah.
you're incapacitated, and there's no
If you're
set
incapacitated,
way.
how do you know you're
Well,
incapacitated?
the document has to set forth a way to do that. And the reason I don't generally recommend them is it can be hard to prove it, or it can be time consuming,
Yeah.
right? Like a lot of times it'll say, in order to prove it, you have to have a doctor's note and go through a physical examination and blah, blah, blah.
Right. And then go to
Or
a
you can have a
judge.
committee of people, friends and family that declare it. Well, that just kind of leaves a little room for mischief, in my opinion. So, but some people are just not, they're just not trusting or not comfortable with giving somebody sort of immediate access to their financial accounts with a, sort of general durable power of attorney. And so they insist on a springing power of attorney.
Okay, so let's say Brierley's dad makes her the financial power of attorney, does a durable power of attorney, financial power of attorney. But he can still do his finances now.
Absolutely.
When does she step in? Just when she sees...
Yeah. I mean, the ideal situation is he's declining and he asks you to take over with bill pay, right? Like he's still aware and conscious enough to say, hey, I just don't want to do this, or I realize that I can't. Please help me with this stuff. And then you take the financial power of attorney to his banks, his financial institutions, his broker, whoever handles his accounts, and give them a copy or an original of the power of attorney and say, hey, I'm going to start helping Dad with some stuff. Again, as long as he's legally competent and has legal capacity, they can both still act. Right? Okay. But again, the ideal situation is he says, I don't want to do this anymore. Brierley, you take over. Yeah. The hard part is when they're, especially with dementia and Alzheimer's, they're not really acknowledging that they're slipping, and you're trying to take care of him, but he's coming in behind you and, sending money to some scam charity. Right. That's what we see a lot and is really worrisome.
Yeah.
And so, people ask about, well, can I get him declared incapacitated and take away his rights? Well, that's really hard. You have to go to court and prove that, and that can damage relationships, obviously. So again, the best situation is he sort of realizes it and lets you take over. But there are certainly situations where they're not willing to give up, their power and control.
So when it comes to financial power of attorney, there are two options: the general durable, which you said, and then the springing.
Yeah, and then there's another option. So both. Oh. So there's, and it's kind of different. So the springing and the durable can be general in the sense that it grants your agent all powers over any financial assets, any property that you own. Basically, they can step into your shoes and do anything you could do with respect to your property. Okay. The other is a limited power of attorney. So as you can imagine, if you own a business with somebody and you want your spouse to manage your sort of general financial accounts, but your spouse doesn't know anything about the business, and you don't really want him or her voting your stock, for example. Yeah. You can give a limited power of attorney to someone that is limited to certain things, voting the stock, or I'm going to be out of town for this real estate closing. Can you go sign all the documents for me?
Okay. So I've done a limited power of attorney many times then.
Exactly.
Okay, got it.
Yeah.
Yes.
But for something like you and your dad, and we want a general power of attorney that allows you to do anything he could do. Yeah. Yeah. Okay. And then, of course, as an agent, you have a fiduciary duty to act in their best interest. You cannot use, their money for your own benefit. They or somebody on behalf of them could sue you if you're doing shady things with their money. And we have certainly, we had an uncle and the nephew was the power of attorney, and he took all the uncle's money and invested it in Ponzi schemes and lost it all. And then we spent 10 years suing him and trying to get it back, So, I mean, it is, it's a serious document. People can take advantage of people, and then, your recourse is to sue them and try to get the money back, but sometimes it's gone. So, when I describe like who you should choose as your agent, it is someone that you trust implicitly. And as you can imagine, especially people that don't have kids and, or a spouse, picking an agent is tough, who do I trust the most, right? And that's where I often see the fights, is where like a niece or nephew or cousin is named and somebody else gets wind that maybe they're, not acting in the best interest of the principal, and, what can we do about it? Yeah. So it's not easy. And that's why some people resort to a springing power of attorney, because they just don't trust anybody enough to give them that full authority, from day one. Yeah.
Well, and I'm guessing if we do it now at our age, we probably need to revisit it every so often. Because it may change. I'm thinking about my will that I did 13 years ago, which I don't know where it is. I got to find it and update it. But the person I put in charge of like my kids' trust, should something happen to me, is not who I'd use now. Yeah. And I need to get
tell people every 3 to 5 years, pull out the will, the power of attorney, medical directives, look at who you've appointed, look at the terms of the trust for the kids. Back then, you may have created a trust that terminates at age 25. Now, if your kid's 21 and you're like, I don't know if they'll be ready to handle all that money at 25, maybe we need to extend those ages. Yeah. That happens all the time. And looking at executor, trustee, guardian for your children, those things change over time. Yeah. Who's going to be best for those roles. Yeah. And so, I say every 3 to 5 years, unless there's a huge sort of life-changing event, right? Okay. A birth, a death, a big asset change, something like that.
A divorce.
Yeah, exactly. Yeah. Then, come on in and let's talk about if those decisions still made sense. Okay. Make sense today.
Okay. Yeah. This is helping so much.
So anything else that someone like me should consider with my dad? Because if not, then I feel like we need to go into like, what the heck should we be doing?
Yeah. And again, a lot of this applies to y'all too. But I mean, obviously a will, right? And you said he has one, but of course, your dad has no obligation to share those documents with you or to, talk to you about those. But in my opinion, it's smart for him to do that if y'all are going to be in charge.
Yeah.
And, start keeping a list of accounts and passwords. Because if something happens to him suddenly, the hardest part of administering an estate, or even if he hasn't passed away, he's incapacitated, is where are all his accounts?
Yeah.
Who are his advisors? How do I get access to these things? What are his monthly bills that I need to make sure, we keep paying for, right? So to the extent parents become comfortable sharing that with their adult children, the easier it is for those adult children to administer, their estate.
Yeah.
Again, whether they're still alive or passed away, on the back end.
Yeah.
Because so much of that is just in their head, and nobody knows about it. And with so much online billing now,
Right.
it's
Yeah,
not,
right.
it used to be you go to the house and you get all their bills.
You collect the
You
mail.
collect the mail, and then you figure out where all the accounts
Yeah.
are. But that's
Yeah.
not
No.
the deal anymore.
No.
And so, keeping and there are tons of really good resources, apps and software and stuff to keep sort of running list of accounts and passwords that are super secure. And, it's hard, but the best thing that I can think of is like, one of those where there's one master password that you maybe put in a safe and say, hey, Brierley, if something happens to me, come get the master password. And that gives you access to this list that has all the account numbers and the
Right.
separate
Smart.
passwords for those.
Right.
But it's only as good as you keeping up with it,
Yeah.
right? I mean, I always say I'm going to, passwords are going to kill me. Like keeping up as they change and,
Yes.
update is very tough.
Yes.
So it's easier said than done. But when you're in that later stage of life, I do think that's something to talk to your parents about,
Yeah.
is keeping up with a list like that. So then, of course, okay, back to a will. A will obviously doesn't come into effect. And so let me back up. Powers of attorney and medical directives are effective as long as you're alive. Once you pass away, they are not effective. A lot of people have the sort of incorrect notion that your agent under a power of attorney
Oh.
can continue to act for you when you die. They lose all authority when you die.
Okay.
Then
That
your
is very
executor,
helpful.
once your executor is appointed, which that's a process, that's called the probate, estate administration
Oh,
process,
yeah.
getting them appointed and getting them what's called letters testamentary, they have to go through that process before they then have authority over all your accounts once you pass away. So having a good will and having the original, because that and like everything is going digital except wills. You still have to have the original will to probate it and get those letters testamentary. You can probate a copy, but you have to have a hearing. You have to bring the witnesses in. It can take like 3 months in Jefferson County. It costs more. So keeping up with that original will is really important.
Okay. Who all, because I was so proud of myself 13 years ago.
Yeah.
I made a will. I was like, oh, I'm so ahead of things. And then I realized I just have it sitting in my own filing cabinet. It's no good if no one knows that I
Exactly.
have one
Yep.
or someone important doesn't have a copy. So what do you recommend for who should have a copy or how you let people know,
Yep.
hey, I have a will should something happen?
Yeah, so my recommendation is keeping the original in a waterproof, fireproof safe of some sort, not just a file cabinet.
I'm thinking about where mine is right now. I'm like, oh,
It's okay. We can fix that. So, I went and got a little document safe at Sam's or Costco.
Okay.
We're in the South. A lot of us have gun safes. People
Yeah.
keep them in gun safes.
Yeah.
Safety deposit box is
was
an
gonna ask you
option,
that.
but my beef with that is that you can't access it generally on a Saturday or Sunday, right?
Right.
And somebody else has to have access to it. You're dead. And
Right.
like getting somebody the code or the key or whatever,
Right.
that can be a pain.
And
Most people
your-
don't think about that.
And your financial power of attorney doesn't
No,
have that
no.
anymore.
Well,
at the
you're
bank
dead.
because you're dead.
Yep, exactly. So
By the way, where should you keep the key for your safe deposit box? Because this is probably where I'm going to fail.
yeah, I would say, yeah. I guess, yeah, a safe.
Yeah.
You can keep it in a file cabinet. I guess it would. I don't know if it would burn in a fire, but
I'll tell you where my things are.
But what I would,
Let me guess,
and
your
in terms of,
underwear
yeah,
There's one in there.
I love it.
There's another in my jewelry box.
Oh my gosh. Yeah. So, a little a little document safe or even a little gun safe or whatever, that's under your bed or somewhere. But yes, it's only as good as somebody else knowing about it.
Yeah.
So again, like if you're, even with a married couple, I always tell them, like, it's not, if y'all go down in a plane, somebody else needs to know where your stuff is, right? So it's not good enough that just y'all know it. So, if you're comfortable sending a copy of your will to your backup executor, right? Most spouses name each other and then name a backup.
Okay.
Yeah.
But of course, if you don't have a spouse, you're naming somebody that presumably doesn't live with you. So if you're comfortable sending them a PDF copy of the will, power of attorney, medical directive, I definitely recommend that.
Okay.
The problem is, of course, if you change your mind down the road and you don't want them to be that person anymore, and then you either have to tell them or you don't tell them, and then they're surprised, right? So there's
But
that.
you're dead.
But you're
So
dead.
you're dead.
Yeah,
So
exactly.
That's
exactly.
their problem now.
If you do name somebody as your agent under a power of attorney, and then you change and you give them a copy or you tell them that and you change your mind and you do a new one, you really need to let them know about that because they still think they have authority over your financial accounts. And if they don't know that their power of attorney is invalid anymore, they could, either be mischievous and do something bad or unmischievous,
Right.
no ill will, no bad intent, go do something with it thinking they're helping you out.
Right.
So it is important to let them know, I've revoked that power of attorney, and just leave it at that.
Okay.
So, sending people copies of things, again, that's kind of personal decision. I think it's smart if you're comfortable doing that, but I get it if you're not, because if you change your mind, that can be tough. And then at least letting somebody else know where they can find a copy or where they can find the originals. Some people aren't comfortable telling the people they've named yet, so they tell me. But then I'm like, okay, well, then you at least need to tell somebody who your lawyer is, right? Again, it's back to who are your advisors?
Yeah.
How do they know to call me?
Right.
Yeah.
People give me letters to hold in the file to give to their family when they pass away. But unless they know, it's me.
Contact.
Yeah. Some firms, some financial institutions have will vaults where they can keep originals. So like if you've named a bank as your trustee or executor, they will usually have a vault where they can keep the original. But again, they do check the obituaries. That's part of their job. But it is best to let a family member or friend know, hey, XYZ Bank is my executor. So if something happens to me, call up somebody or call my lawyer and she'll know to call the bank.
Right.
So letting somebody know about these things is important.
Okay.
Yep. Or again, and again, it's you don't necessarily have to tell them what's in the document, but where it is, or here's the key to the safe, or here's the code to the safe.
Yeah.
Yeah. So, as you can, with people who don't have, extended family, friend situations, it can be tough.
Yeah.
Yeah.
Is there anything that in a will that you see that people commonly forget about or don't think about to add or
The thing that nobody thinks about, which is good, nobody needs to think about this except me, is if you and all the people you've named in your will, typically it's spouse, kids, that's where all your stuff's going to. What if y'all die in a common accident? What if you go down on the plane? What if whatever? Where do you want your stuff to go? Nobody thinks that that's ever going to happen because you don't want to. That's a horrible thing to think about. But it happens. And if you don't say where your things go, Alabama law says that they go to your heirs at law, which is, grandparents or parents, otherwise siblings, otherwise nieces and nephews, otherwise we can get out. I've had to do an heir search of 100 different second and third cousins because somebody passed away with no lineal descendants, no spouse. And the will just said heirs at law. So I had to go find all those people. Yeah. So, and most people don't know those people or, it's, just being kind of funny. Most people don't, love all of their cousins or nieces or nephews or whatever, which, whatever, we're human. And so, or, they have a church or a charity or a certain family member that's more near and dear to their heart.
Yeah.
So I do have people, I'm like, go home, drink a glass of wine, talk about it, think about it. Don't stress over it. The chances of this happening are very slim. But in that rare situation, where do you want your stuff to go?
I never would have thought of that.
Yeah, yeah. No, and it's depressing to think about. But like you travel with your girls all the time.
Yeah.
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 The 5 of us travel together all the time. So, where's it going?
Right. Where's it go?
Yeah, yeah. And that might be something, to think about and update every now and then as things change. Yeah.
So if you review it every 3 to 5 years, let's say someone works with you, they've done all the paperwork, then, 3 to 5 years they sit down and they want to make a small change.
Yeah.
Can they do that themselves?
No.
Okay.
So a will has to be, at least in Alabama, witnessed by 2 unrelated witnesses and notarized. So if they want to make a change to it, we can either do what's called a codicil, which is like an amendment to the will, and that also has to be witnessed and notarized. So, they could try to draft it, but, getting it, most people don't realize it has to be witnessed and notarized. Or depending on the change to the document, sometimes it's actually more efficient and cheaper to just update the will because it's on, it's in Word. We just go in and do our thing. And so for a substantive change to executor, trustee, guardian, or change to the what I call dispositive provisions. Who's getting what, the terms of the trust for the kids, the ages at which the trusts terminate, the distribution provisions. Those need to be done with an updated will or a codicil. What you can do in Alabama and most states with respect to tangible personal property. So that's cars, clothes, jewelry, antiques, guns, art, all your stuff. Alabama does allow you to leave a memo with your will that's not witnessed or notarized, and it can be handwritten and just signed and dated as many times as you want, disposing of tangible personal property. Okay. So, a lot of older folks really care about their stuff and who gets it,
Yeah.
And so, you hear of little old ladies putting sticky notes on stuff. This is the sort of more formal concept of that, which is, you write out, silver platter to Brierley, jewelry, emerald ring to Jennifer, whatever. That you can do with a memo, update it as many times as you want. You do not have to call your lawyer to do that.
Interesting.
The will says I may leave a memo with my will disposing of certain pieces of tangible property, and I direct my executor to follow it. Although it's not legally binding, the executor, will follow it to the extent they can. So we just recommend that they leave it with the original will. Again, wherever you're storing the original will, in an envelope or whatever, stick that memo with it. So again, practically, it's easily located by the executor.
Right.
So you can do that without a lawyer.
Okay. Interesting.
Yeah, yeah.
Anything else we're forgetting?
I'm sure you've read about, and everybody always asks me about, so again, the word trust in general, it's like, you go to Baskin Robbins and you ask for ice cream. They're like, well, what flavor, right? There are tons of different types of trust, but what I hear about on a weekly basis is revocable trusts. You may call them living trusts. So those are trusts that you can create while you're alive. It's revocable in the sense that you can change it and amend it just like you can a will.
Okay.
And it can serve a lot of different purposes, but the sort of, the general thinking is I want to do a revocable trust to, quote, avoid probate. Okay? So, yes, that is possible. If you create a revocable trust that looks very much like a will, what it says is you're the grantor, the trustee, the beneficiary during your lifetime. So you maintain control and access to whatever assets are owned by the trust. And then when you pass away, it says, upon grantor's death, this is where the assets go. So that's what a will does, right? So the idea is with a will, if you own assets in your individual name when you pass away, those have to pass through your will, through your estate, through the probate process. And the probate process gets a bad rap because in a lot of states, it's really expensive. It's really time consuming. It's public, right? Your will becomes a public record once you pass away. Some states require you to file an inventory of all your assets, which that's disturbing. Alabama does not. You do not have to file an inventory. The fees are very minimal, and you have to keep your estate open for a minimum of 6 months. So in my opinion, Alabama is not one of those states where you want to avoid probate like the plague. California, New York, Florida, you do. A lot of different other states where you do. And so in those states, it's more common to have what's called a pour-over will, which just says, if I own anything in my individual name at my death, send it to my revocable trust. And then the revocable trust disposes of your assets, has all the, everything goes to my spouse, otherwise my kids, in trust, and here's the terms of the trust. It has all that language. Okay. But the rub is that that very few people follow through with is that in order for that to be effective, to avoid probate, you have to transfer ownership or title of your individually owned assets into the name of the revocable trust before you pass away. Or your assets, if you can name a beneficiary, you name the revocable trust as your beneficiary. Because like I said, if you own assets in your individual name, they have to go through the probate process to get to the revocable trust. Mm-hmm. So you have to do a good bit of work on the front end to transfer assets out of your individual name and into the name of the revocable trust. It's a transfer of title, of ownership, in order to truly avoid probate. Once you do that, again, you're in total control. You can use those assets just like you would if you own them in your individual name, but it's taking that step of finding all of your assets and doing the paperwork to transfer them over to actually accomplish that goal of avoiding probate.
And is it a big deal to set up a revocable trust?
No, again, it is just as easy to do a will as it is to do a will. Okay. So, from my perspective, it's not a big deal.
Okay.
But I just have to caution clients that, this is not the magic pill or, magic solution to avoiding probate, you having a revocable trust. You have to fund it as well.
Okay, so let me ask what could be a very stupid question. So let's say I want to put my house in trust to my kids.
So we would do a deed. We don't want to give the house to your kids now, right? So we would do a deed that transfers the house into your revocable trust.
Right.
And your revocable trust says that when you die, all your assets, including the house, go to your kids.
But I have to get the deed on my house.
You have to do the deed.
Changed.
Yes.
And what a pain.
That's what I thought
and
you were saying.
that's what people forget to do.
Is that you're like, I got this one part done, and then I have to go.
And then you got to go look at all your bank accounts
to my house.
And if you've got IRA, retirement accounts, IRAs, 401ks, life insurance, look at those beneficiary designations. And this is a really important thing for y'all, people our age with minor kids. A lot of people on their so you created this beautiful will that creates trust for your kids. And you talked about the terms and who the trustee is and at what ages it terminates. But then you go and you name your kids as the beneficiary of your 401k and your IRA and your life insurance policy.
Yeah.
They are minors.
That was my
That
next
is going
question.
outright to them, which means that now we got to go get a conservatorship set up that only lasts until they're 19. You have to post a bond to be their conservator. They don't need the money at 19. There's very few investments that you can make in a conservatorship. The conservator has to post a bond, pay a premium, post a bond, account to the court every 3 years. It is a huge pain in the butt. So if you die without a will and you have minor children, or you leave money to minor children, that's the process you have to go through. So again, there's a lot of homework for the client. Once we create this beautiful will that creates these trusts for the kids, you then got to go update your beneficiary designations to send those assets, those types of assets, the ones that are controlled by beneficiary designations, to the trusts for the kids, not to the kids outright.
So, okay.
Yeah.
So, and this is a reminder too to go check your beneficiaries, because that didn't even dawn on me really when I got divorced, and 5 or 6 years later I'm like, whoa,
right.
Whoa, the ex is getting all the things.
So I didn't know. I think we did set up a trust. I don't know. I'm sure I hadn't done it right with trust if I have one. In fact, I'm feeling like I just need to scratch off. Scratch.
I know. And this whole conversation, like I was like, we're rolling along, and I'm like, I think I got this. I think I got this too. Okay, and then now we're getting to the point where I'm like,
Nope.
Jennifer, take over the wheel.
Yeah.
Oh, man.
So
I know. And I wish there was, again, like I wish there, there's only so much I can do. Like I have to give my clients homework to go update their beneficiary designations, to transfer title to their Rev Trust, and inevitably it doesn't all get done, and then we have issues.
So I was going to say, when I was updating mine, like my state retirement, I have state retirement. So I didn't know, I think I may have ended up putting my mom down just because I knew my mom, she's going to use it to take care of the kid or do something. But I need to do it to the trust. Yes. I need to create a trust and do it to that.
Or you have created, it sounds like you've created trust under your will. So you need to name the trust created under the will as the beneficiary. Or if you do a Rev Trust that creates trust, then you just name the Rev Trust and it'll get there.
Do you recommend a Rev Trust, or do you feel like it's so complicated that it might just not be worth it?
Yeah, I go through this spiel with everybody, again, I don't feel strongly either way. I think it's great if you do your homework and you follow through. It's just in my experience, very few people follow through with transferring all of their assets. And if your goal is to avoid probate and you're not going to do all that, then I don't think it's worth it. But a revocable trust, a really great thing about a revocable trust is that if you own property in another state, real estate, okay, like real property, a house, land in another state, and if you're a resident of Alabama and you pass away in Alabama, we probate your will in Alabama, obviously, because you're a resident here. In order to transfer real estate in another state, we have to go probate your will in that state as well. So we're doing 2 probate estate administration processes.
Man, I got a lot of states to go when my mom goes.
Yeah, and it's expensive and time consuming, right? And you have to hire a lawyer in that state, so you're paying 2 lawyers' fees if your lawyer's not licensed in that state, which they're probably not. Or maybe they have an office in that state, but maybe not. So what a great use of a revocable trust is create a revocable trust, transfer your North Carolina mountain house, for example, into the name of your revocable trust so that we don't have to probate your will in North Carolina. The revocable trust owns the property and it says where the property goes. We still have to file a deed up there, but we don't have to go through the whole probate process, which, can be a pain in the butt.
Right. Okay.
So I do. If you own properties in multiple states, I think a revocable trust is a great tool to avoid an ancillary estate. And then, of course, I have clients who privacy is a very big concern. And the revocable trust does not have to be recorded when you pass away. The will does. It technically becomes public record. My first comment is, most of my wills, they're not that sexy, right? They say to my spouse, otherwise to my kids.
Yeah.
Right.
In a trust, here's my trustee, here's my executor. Our wills don't typically list your assets.
Right.
Like I said, in Alabama, we don't have to do an inventory. So I want to first explain to my clients, here's what's actually becoming public record. Are you still concerned? And some of them are, and especially people who do wills that maybe cut out a child or treat a child differently or do some, weird things or actually name specific property. Sometimes we have to do that in a will.
Yeah.
And so for those folks or folks who are, famous, right? They want privacy. So for that reason, a revocable trust can be a great tool because you can put all your sort of dirty laundry in your revocable trust and it never gets probated. It never becomes public record. So your will just, regardless of whether you want to avoid probate, the only document that becomes public record is a document that says, send everything to my revocable trust. And then your revocable trust says, cut out my second child, do all these mean whatever things.
Right.
Yeah. Or I have an illegitimate child, give them some money.
Right.
That has happened before. So that is another. So privacy, avoiding an ancillary estate administration. And then I do have folks like with your dad, where if we see them slipping, some people, it makes sense to go ahead and have him create a revocable trust and name you or your brother or both of y'all as co-trustees. It's very much like a power of attorney, but we go ahead and we transfer those assets into the name of the revocable trust. And while he can technically revoke it, y'all are trustees, and so can kind of more easily manage all his assets in your capacity as trustee of the trust that owns all of his assets.
Got it.
But again, you got to go through those steps to transfer the assets to the revocable trust. So it certainly has some uses. And in states where probate is expensive and time consuming and you have to do an inventory and pay a lot of fees, absolutely you need to be doing that.
Yeah.
In Alabama, I kind of go through this spiel with clients and say, is this really what you want? The biggest misconception is that people think a revocable trust is going to protect their assets from creditors. It is not. Revocable means you can change it, and it's typically for your own benefit, and therefore, under the law, it is not protected from your creditors. So that's the biggest notion that I have to explain.
But does it protect you at all from any type of estate tax?
No.
Okay.
No. All the assets are still included in your estate for estate tax purposes.
Okay.
Yep. Yeah.
Got it.
If we're trying to do creditor protection or estate tax, deal with estate taxes, that's when we start talking about irrevocable trusts. And again, there's 100,000 different types of irrevocable trusts, and it depends on what your goals are, what the assets are, all that kind of stuff. So that's a whole sort of different.
Yeah,
that's a different podcast.
I don't think my brain can handle that right now. I'm like, at this point, I'm like sitting back in the chair, like, woo.
But I'm sitting here thinking about you, Brierley. I know your dad has a home in Pennsylvania and then one on the Jersey Shore. So probably you really need to get him to set up a revocable trust.
Yeah.
So you aren't
I need my mother to do it too, especially, you know.
definitely.
I bet your mom's done it. You don't know?
I don't know that she's done a revocable trust.
Gotcha.
And if you're going to go ahead and do a revocable trust for out-of-state property, you might as well just make that your dispositive instrument, right?
Yeah.
Do a pour-over will and then just have the revocable trust dispose of everything. And then you just got to get your probate assets into the rev trust after you pass away, you know, and then it'll all be fine. So, yeah, there's a lot.
Okay, last question. Tell our listeners, it's going to be a little bit of a long question. Tell our listeners where they should go to look for an estate attorney, or how they can find one, like what your advice is for finding one that jibes with you.
Yeah.
And then the follow-up question that I have to that is that we really are in a time where we don't always live where our parents live. Right. And so is there a way to identify, like, for example, you work for a firm. If your firm has offices in Florida and Mississippi and Texas, like, does that mean that if my parents reside there, you and your firm can help across multiple states?
If I have estate planning attorneys in those different offices, yes. It's not all law. I do not claim to do any other type of law than estate planning, business planning, and tax law.
Right.
We have offices all over the country, but we don't necessarily have estate planners in all those offices.
Okay, so that's the other
key.
part to ask.
Yes.
Okay, great.
Yeah. But I mean, I would say, word of mouth is probably the best way. You do want to find somebody, in my opinion, that jives with you, because you have to share a lot with your estate planner, a lot of personal stuff. You have to have sometimes tough decisions. So finding somebody that jives with you personally, I think, is really important. Yeah. And it's hard to get that from a website. I mean, of course, you can read their bio and you can look at their picture and you can get an idea. But, to the extent you have time and energy, I would interview a couple different folks.
Yeah.
If you don't have somebody, a good friend or family member, to recommend somebody to you. Yeah. I would first ask close friends and family members who they use, what they're like, if they're happy with them. I think that's how I get most of my clients.
Right.
Really, all of them is from referrals.
Right.
And then if you don't have that, then, in most cities, there are what's called an estate planning council. Like a group of estate, a group of, it's like a professional group, right? Okay. That estate planners, accountants, and financial planners are a part of. So maybe peruse that website and see who's in the estate planning council. There's an amazing national organization called ACTEC, the American College of Trusts and Estates Council. It's really hard to get into. Like you have to be a very, sort of sophisticated, well-rounded estate planner to get into that. So that's a great place to start as well. And there are people from almost every city in AgTech, definitely every state. So that's a really good source. And then, of course, ask your financial planner, your banker, your life insurance agent, your accountant for a referral.
Yeah.
That's where I get a ton of clients from, is those people, because
Yeah.
they've worked with estate planners
Right.
before, and they can, recommend who they like to work with the best. Or, a lot of people like that, like me, they'll know multiple estate planning lawyers, and they'll know their client and their personality and their assets and their issues, and say, I think this person matches up well with you.
Right.
So,
Right.
yeah.
If someone wanted to do an interview, so like, I mean, having been divorced, like I did this with the divorce attorney
sure.
process. So you can just call and
Yep.
say, "Hey, I just want to come in and
Yep.
do a consult."
Do it all the time.
And so what does that look like? Like, what would I need to do? Would I literally just call and say, "I would like to make an appointment"?
Yeah. Yeah. I would ask if you're comfortable going ahead and sharing with me like a financial statement and information about your family, so that I can really, so we can sort of get into it on the first meeting. But if you're not comfortable with that, and some people aren't, we just have a sit down meeting, and I talk about my process and my team and my cost and my timeline.
Right.
And we just kind of chit chat and get to know each other. And it can be as simple as that too.
Okay.
And that's, of course, a no charge.
Oh, you don't charge for that?
No.
I never
divorce
thought about
attorneys
that.
charge for that.
Really?
Yeah.
Yeah. If I'm not giving legal advice, I don't feel like I can charge.
Got it.
Yeah. Now, if we get into it,
Yeah.
and we actually, I'm giving you suggestions and legal advice, and you're making decisions, and then you do choose me, I probably will charge for a part of that meeting.
Yeah.
But if we're not really getting into any of the substance of it, even whether or not you hire me, I'm not going to charge you for that.
Got it.
Yeah.
Got it.
One more thing. This is kind of jumping back, but with planning with parents, I can't forget to mention this. So often what happens is, parent is getting older and doesn't want to do a lot of the bill pay anymore. And so it's easier in their mind to add a child to their bank account
Yes.
to help them pay the bills.
Yes.
Okay.
What you're most likely doing when you do that is you're adding them as a co-owner, not just a co-signer. And what that means is when you pass away, ownership
that's
of that
theirs.
account is going to that child. And what if you have 3 kids and your will says, I want to split everything 3 ways? It doesn't matter. If you co-own an account with somebody with rights of survivorship, ownership of that account is going to the surviving owner. Same with a house. People are like, I want to go ahead and put the house in the kid's name. It'll make it easier. Like, first of all, that's a taxable gift. Second of all, you may be inadvertently cutting out other kids. So what I try to stress to people is how things are titled and whether or not they have a beneficiary designation is super important. Again, your will only controls what you own in your individual name, and that is not otherwise governed by a beneficiary designation. So assets that are owned jointly with somebody else and assets that have a beneficiary designation are not controlled by the will. And so we had a pretty tough situation where, guy was, I don't even think he married this woman. It was a lifelong partner kind of thing, but not the mother of the child. And he created this will that very carefully divided things between the lifelong partner and the daughter. Well, turns out he had named the lifelong partner as beneficiary of all his accounts. And so everything went to her. And there was nothing the will could control or do. Luckily, she was a lovely woman, and we did some disclaimers and some stuff to get what was intended to go to the daughter, but that does not always happen. And it can be a huge mess. So as part of this process, figuring out, a lot of times, especially married couples, I say, give me a financial statement. And they give me a statement that just has all their assets listed with values, and that's it. And I'm like, well, how are things titled? Is it joint? Is it in your name? Is it in your name? Is there a beneficiary? And they don't necessarily know that off the top of their head. We got to go look at the deed. We got to go look at the bank statement. We got to go look at the life insurance beneficiary. So it takes a lot of work.
It does.
But it's really important in order to carry out your wishes.
That right there is why you need a state attorney.
Well, and that is probably the biggest mistake I see.
Yeah.
And it's sad because you don't figure it out until it's too late.
It's still too
You
late,
think
yeah.
you're doing the right thing.
Exactly.
Yeah.
And like we had one where I think there were 4 kids, 3 sons and a daughter. And the daughter lived in town, and she was very busy, like executive person, but she took care of her parents. And so they put her on all the accounts. And she is very wealthy and has a taxable estate. And so all those accounts went to her. And for her to get those, a fourth to each of her brothers, she's having to make annual exclusion gifts to them over like 5 years to be able to do it without using her lifetime exemption. And it's a huge pain.
Wow.
Yeah. And again, thank the Lord she has a good heart and
Right. That's what I
wants
was
to
gonna
do
say.
what her parents want.
Right.
But not everybody does.
Wow.
Yeah.
Well, and going back to the joint bank account thing, in my experience, dissolving a joint bank account is not easy.
Yeah.
Banks do not like to do it. And I just remember getting divorced and having to dissolve
Gotcha.
them and the paperwork that
Really?
they want to see.
Yeah.
So.
And like if parent puts you on it and then they become incapacitated and you realize it, is the bank going to give you a hard time about undoing it?
Right.
When the parent doesn't have capacity, It's tough. Yeah.
Well, this
So-
Wow, this is amazing.
This was a lot, but
I know.
really, really good.
Yes. Yes.
And I'm sure I should give some sort of disclaimer that, I'm nobody here's my client and, talk to your own estate planner.
Yeah.
But these are sort of my general thoughts.
They
and
were general
advice.
advice. You gave no specific legal advice. You just
Yeah.
gave very general. That was amazing.
Yeah.
Thank you so much.
Yeah, absolutely.
This is so
my
helpful.
pleasure. Yeah. Good to see y'all. Thanks for having me.
Thank you so much for joining us for the Happy Eating Podcast. I'm Brierley Horton.
And I'm Carolyn Williams. If you liked this week's episode, then don't forget to rate and leave us a review on iTunes. And be sure to hit the subscribe button so you'll never miss a new episode.
We can't wait to have you back at our table next week for a brand new episode. Bye.
The contents discussed in the Happy Eating Podcast, such as advice, studies, text, graphics, images, and other material discussed or presented on the site or podcast, are for informational purposes only. Content is not intended to be a substitute for medical advice, diagnosis, or treatment. Always seek the advice of your mental health professional or other qualified health providers with any questions you may have regarding your condition. Never disregard professional advice or delay in seeking it because of something you have heard on the Happy Eating Podcast.
If you are in crisis or think you may have an emergency, call your doctor or 911 immediately. If you're having suicidal thoughts, call 1-800-273-TALK, that's 8255, to talk to a skilled trained counselor at the National Suicide Prevention Lifeline. If you are located outside the United States, call your local emergency line immediately.